Ladies and gentlemen, there is justice and then there is law. The two aren't supposed to be mutually exclusive, but sometimes some rulings make you question that assumption. The law gives bail to an almost 18-year-old who killed two with a speeding car. But is this justice? I ask you that question after presenting the facts of the case to you in the next 2 to 3 minutes. You know what has happened in Pune. A rich kid in a Porsche, dead drunk, runs over two techies. The locals catch this drunk kid, hand him over to the police. And then the police, the hospital, the doctors, the parents, the grandparents, all put up such a stunning display of brazenness and corruption that you begin to question every institution in this country. Today, the Bombay High Court has ruled that the brat behind the Pune Porsche horror will walk free again. Last time, the Juvenile Justice Board had allowed him to walk free after asking him to write a 300-word essay on the perils of drunken driving. So you kill two people, and all it takes is an essay for you to be set free within 15 hours of murdering two people. Today, the High Court has said that he's a child who needs to be treated as a child. Is a 17-year, 8-month drunk teen who kills two people a child in conflict with the law? And I underline the word a child. As I ask that question, let me tell you what the court based its release order on. The Bombay High Court has ordered the unconditional release of this juvenile from the observation home, terming his detention illegal. The teen will now be under the care of his aunt, as his parents and his grandparents are under arrest for an attempted cover-up. You know that story. Today, the Bombay High Court bench also observed that the court is bound by law as well as the aims and objectives of the Juvenile Justice Act and must treat him as any other child in conflict with law, separately from adults, despite the seriousness of the crime. This is what the court has said. The court further reiterated that since he is under 18, his age needs to be considered. Now remember, this is in consistency with what the High Court had observed a few days ago, in which it had observed that the accused too was in trauma and needed to be given time. Now, if you are feeling aggrieved by the fact that this brat who destroyed two families is set to enjoy the comforts of his family home once again, your blame should actually lie squarely with the Pune police. Because not only did the local police force pamper this brat by giving him burgers and pizzas in custody and then deliberately delayed collecting his blood sample, they also did something far worse. Initially, they charged the boy with relatively benign sections of the IPC that gave the JPP, that's the Juvenile Justice Board, grounds to grant him bail within 15 hours of his arrest. It is this bail order that has been upheld by the High Court today. It is also this bail order that was never challenged by the Pune police in the last 5 weeks. Can you imagine that? The end result before us is a classic conflict between what the law says and what justice demands. For instance, the law states that the accused is a minor and must be treated as such. But at 17 years and 8 months of age, how are his mental faculties any different from a legal adult? The law wants him to be treated as a juvenile, regardless of the severity of his crime. But we ask, for a crime so heinous, should he not be tried as an adult? Next, the High Court, in its interpretation of the law, has stated that his detention in an observation home is illegal since he has already been granted bail by the Juvenile Justice Board. But given the fact that the Juvenile Justice Board has already been exposed as compromised, should a bail order given by it still be allowed to stand? Finally, if the court is so concerned by the trauma the accused is going through, shouldn't it also ask if his trauma is worth more than that of the two families he has completely destroyed forever? Maybe the court should listen to what the families feel. Listen to the mother of one of the victims.
मुझे पूरा विश्वास है अपनी न्याय व्यवस्था में, उनने भी कुछ सोच के मतलब ये फैसला किया होगा। और आगे बस मेरी एक रिक्वेस्ट है न्याय महोदय से कि एक माँ का दर्द समझे। मैंने अपनी एक बेटी को खोया है, तो उस स्थिति में मतलब क्या वजह है, क्या है, उस हिसाब से मतलब उसको सज़ा दे। तो बोलना चाहिए कि इस केस में सही न्याय हो तो जनता भी अपनी न्याय व्यवस्था पे भरोसा कर सके। और मुझे पूरा विश्वास है कि मुझे ज़रूर न्याय मिलेगा, क्योंकि महाराष्ट्र सरकार ने भी हमें पूरा विश्वास दिलाया है कि न्याय होगा।
I'm also going to introduce Akhilesh Awadhya, who's the uncle of one of the victims. My guest this evening, Dr. Vikram Singh, is a former DGP joining us on the broadcast. Advocate Swapnil Srivastava is a senior associate at MZM Legal. He's joining us on the broadcast. And Naveen Chomal is a lawyer. He's joining us on the broadcast as well. सबसे पहले तो अखिलेश जी मैं आपके पास ही आना चाहती हूँ. मैं अपने मेहमानों के पास बाद में जाऊँगी. सबसे पहले आप पे आऊँगी. अखिलेश जी, पहला सवाल तो आपसे सिंपल है. कोर्ट ने बोला है कि अगर ट्रॉमा दो फैमिलीज को है तो ट्रॉमा इस लड़के को भी है. इस बात से क्या आप सहमत हैं?
ये कोर्ट का अपना व्यू है, मैं इससे पूर्णतः असहमत, क्योंकि उसका कहीं भी दिख नहीं रहा। जिस समय घटना हुई, जिस रात को, उसी दिन उसने सुबह वहां पर पुलिस वालों के द्वारा, उनके फैमिली के द्वारा उनको पिज्जा अवेलेबल कराया गया। उसने आराम से पिज्जा खाया था और आराम से वो उसको जब बेल हो गई तो भी बड़े आराम से, उसको कहीं भी गिल्टी महसूस नहीं हो रही कि मैंने इतना बड़ा अपराध किया। तो जिस प्रकार का माननीय न्यायालय ने वो लिया है कि ड्रामा में, मैं इस बात से असहमत हूँ। इसी बात को लेकर सुप्रीम कोर्ट जाना चाहिए पुणे पुलिस को, क्योंकि वो कहीं भी से भी उसके परिवार ने, उसकी मां ने ब्लड बदल दिया, उसका ब्लड सैंपल बदल गया और इसी प्रकार से उसको बेल मिल गई। और बहुत सारी पुलिस इसी प्रकार से उसका जो वो था ड्राइवर, उसके बाबा जी ने ड्राइवर को धमकाया चमकाया। तो वो और उसका परिवार कहीं भी ट्रामा में दिखता नहीं है किसी भी मतलब जैसा न्यायालय कह रही है ट्रामा में। तो क्या न्यायालय का अपना है, मानना है, जिनका व्यू है, बल्कि मैं इस बात से असहमत कि वो ट्रामा है।
आप लोगों को क्यों लग रहा है कि उसको एक अडल्ट की तरह ट्रीट करना चाहिए, ना कि एक जुवेनाइल की तरह? क्योंकि अगर आप बॉम्बे हाई कोर्ट की बात सुने अखिलेश जी, तो बॉम्बे हाई कोर्ट बहुत क्लियरली कह रहा है, दिस इज अ चाइल्ड इन कॉन्फ्लिक्ट विद द लॉ. ही इज अ चाइल्ड, ही इज अ माइनर हु नीड्स टू बी ट्रीटेड एज वन.
जितने भी उसके कृत्य थे, वो स्वयं दारू पीने गया था, पार्टी मनाने गया था। उसने 45,000 की दारू अपने साथियों के साथ पी और जबरदस्ती उसने ड्राइवर को हटा के ड्राइविंग सीट पर बिना लाइसेंस के, बिना रजिस्ट्रेशन की गाड़ी 250-230 की स्पीड से चलाई, जबकि वो भली बात जानता था, वो इतना समझदार था कि हम ये इस प्रकार का कृत्य करेंगे तो निश्चित रूप से किसी न किसी की डेथ संभव है, क्योंकि इतना भीड़ भाड़ इलाका था। जो जिस समय घटना हुई, काफी लोग रोड में थे। ये तो उनका दुर्भाग्य था कि वो हमारा भतीजा था और उसकी डेथ हुई, नहीं तो 100% किसी न किसी को गाड़ी उस दिन एक्सीडेंट होती और दूसरा व्यक्ति मरता और ये भी मर सकते, इसमें कोई वो नहीं। अब पुलिस ने वहां पर क्या एप्लीकेशन लगाई उसको बाले की मारने के लिए, उस एप्लीकेशन पर क्या कार्रवाई हुई, इसकी हमको कोई जानकारी।
ठीक है, आप जरा हमारे साथ बने रहिए अखिलेश जी. आपसे एक तीसरा सवाल भी पूछूंगी, बट माय नेक्स्ट क्वेश्चन इज टू डॉक्टर विक्रम सिंह. डॉक्टर विक्रम सिंह, what do you make of what has happened in court today? As I said, law is one thing. The court was giving us an interpretation of the law where this 17-year-old, 8-month drunk teen is a child in conflict with the law. I understand that the law will say something, but can law and justice be mutually exclusive?
Shreya good evening. How can they be mutually exclusive? And in such a case where two people have been snuffed before their time and have died before their time, there is a larger picture to the fact that this child uh, who is adolescent in conflict with law, I would say the deviant adolescent with criminal propensities, should have got a deed that is commensurate to his mental maturity and physical well-being as is ordained by law, that adolescent in conflict with law within the age bracket of 16 to 18, the Juvenile Justice Board, YG Section 15, is also empowered and should give a verdict whether with his cognitive powers, his physical framework, was he in the position to assess what his actions can have the propensity and the potential to do. As Mr. Arish Ji had mentioned in his statement that he chose to drink liquor with his friends for almost 50,000 rupees, chose to drive without a license, chose to go to from pub to pub hopping, and also kill two people and then try to manipulate the evidence. And I'm very disappointed by the action taken by the police and the prosecution, the misplaced compassion, I would say the misplaced one-sided compassion toward this adolescent, the deviant. I'm aghast at the fact that this is not natural justice. This is perversion of the worst kind. And not to oppose the bail in the High Court, I would blame the Pune police and the prosecution for absolutely being criminally negligent. My words can be very harsh, but this is exactly what we do, that it is a bad investigation, worse prosecution, giving total benefit of advantage and the total advantage to an accused who belongs to, I should not be talking like that, but the fact of the matter is, belongs to a family that is known and accustomed to how to navigate its way through police, prosecution, and wade through. There are also allegations that the grandfather was friendly with the mafia, the most wanted in Indian criminal history. And if that be the case, the blood samples being changed by the mother is in jail, the father is in jail, the grandfather is in jail. I had expected a lot more from the prosecution and the Pune police, but we, like you, I stand totally disappointed. And like most of us, we are absolutely disappointed. We'd expected a lot more.
Swapnil Srivastava, who should we be more disappointed in? Should we be more disappointed in the Pune police that built a very weak case in front of the Juvenile Justice Board to begin with? Or should we be disappointed with the Juvenile Justice Board that has now been exposed as compromised? And therefore, in that sense, should the High Court have gone with what the Juvenile Justice Court did, given the fact that they were so severely compromised? Swapnil, that question was for you.
Shreya, I'm sorry, there was some connection issue. I hope I'm audible.
You are.
So
go
Shreya,
ahead,
I'm sorry, I can't hear you, Shreya.
Go ahead. I can hear you loud and clear. Swapnil, go ahead, please.
Shreya, you're right. The anguish that you feel, that all of us feel, is very real. And both the Pune Police and the Juvenile Justice Board have let us down. There is no denying that. But there are two things that we have to keep in mind when it comes to the question of bail or the cancellation of bail, which has already been granted. First is, what is the purpose of incarceration pending trial? The purpose is very clear. It is to ensure that whoever is the accused person is there to face justice and does not abscond. However, the purpose of pre-trial incarceration is never to punish the accused person. Because the moment that happens, the presumption of innocence, which is a fundamental right under Article 20 of the Constitution, stands violated. The second thing, Shreya, that we need to keep in mind is, so far as the Juvenile Justice Act is concerned, it is indeed true that anybody who's above the age of 16 can be tried as an adult. And an application in that regard is in fact pending before the Juvenile Justice Board, which should be decided expeditiously. But at the same time, we need to keep in mind Section 3 of the Juvenile Justice Act, which states that in the case when you have not been declared as an adult yet, the incarceration of such a person, such a child, should be done as a matter of last resort. Number one. And number two is that any decision that the Juvenile Justice Board has to give, it has to be in the best interests of the child concerned. Now, keeping all of that in mind, the matter goes before the Bombay High Court, and the Bombay High Court declares that the child should be released on the sole ground that the procedure which was followed to send him to the observation home was not proper. So it was more of a procedural issue that led to his release as opposed to anything decided on merits. What actually unfolded was that bail was granted on the 19th of May for whatever reasons that maybe we'll not get into it right now. Thereafter, the prosecution had the opportunity to challenge that. They did not do it. They had the opportunity to move an application seeking cancellation of bail. They did not do it. Instead, they moved for a review under Section 104 of the Juvenile Justice Act. And in this review application, the Juvenile Justice Board changed its order and directed that he be sent to the observation. Now, the Bombay High Court took a grievance to this for the sole reason that the legal considerations that have to be factored in a situation such as this are very specific and pertain to cancellation of bail.
Okay.
So when such factors have not been considered.
Okay, I understand what you're saying. You're saying that the procedure under which this juvenile was sent to the observation home, that was faulty, and it is based on that the High Court has said his bail stands and he will be allowed to walk free. Again, you have explained to me the law. I understand what you're saying. I think we have made that very clear to our viewers as well. But my simple question is, that's the law, is this justice? How is it okay for a court to consider what is in the best interest of the child who is 17 years, 8 months, and not in the best interest of the families who have lost 2 children? Simple point. Where is the justice in what has happened? Prashant Patil, you are the minor's lawyer. To some degree, today has been a successful day for you. I also know for a fact that this case is not going to get over anytime soon, that like Nirbhaya, this is going to stretch as well. But can you help me understand why your client should not be tried as an adult? Why someone like him should be allowed to walk out on bail?
Well, see, there are 2 questions that you raise right now, and I'll just submit one. What is the law point as we speak today? First, you said like whether this particular child in conflict in law, whether he can be treated as an adult. This question has already been answered by a very detailed judgment of the Honorable Supreme Court. There are guidelines laid by the Honorable Supreme Court that if a particular child in conflict in law, he or she commits a heinous offense, quote unquote, then under Section 15 of the Juvenile Justice Act, there is a procedure to treat this particular minor as an adult. Now, what is a heinous offense has also been laid down by the Supreme Court and also by the Act. There are specific definitions, there are specific guidelines, which are all binding upon us as we speak today. So I'll only restrict myself to that particular law. Under that category, Section 304 IPC, categorically it has been laid down by the Supreme Court because it was a similar case as we are speaking right now, which had happened at Delhi, which traveled till Honorable Supreme Court. And then the Supreme Court came to a conclusion that 304 IPC cannot be treated as a heinous offense. That's one part. The second question to me was, how was this person, the child in conflict in law, released on bail? We had moved a writ of habeas corpus. Let's have a larger canvas. What is the law today? The Juvenile Justice Act is something which has not traveled maybe to the viewers, or maybe there is not much of knowledge available about the Juvenile Justice Act in the public domain. And that's why maybe because of that misinterpretation, a lot of misinformation has been spread about this particular case. As a lawyer and as the officer of the court, it's my duty to tell you what is the legal position today. We like it or not, if you and me come to a conclusion that the act needs an amendment, maybe yes. For yes, we are all together in that. Even as lawyers, we'll all be participating in that. But that is for the Honorable Parliament to decide and to draft. When it comes to the legal position as we speak, there's a Section 12 of Juvenile Justice Act. That particular section is very clear. It's completely unambiguous when it says that whether it is a bailable section or a non-bailable section, the Code of Criminal Procedure is not applicable when it comes to an issue of a child in conflict in law. That's how the section is drafted. If that may be the case, that was the backbone of the writ of habeas corpus that we moved before the Honorable High Court. we relied heavily upon Section 12, based on which our petition became admissible and we were heard at length. The prosecution aggressively opposed that particular petition. But Honorable High Court has now come to a conclusion that the child in conflict law needs to be released immediately. We do not have a detailed order in place. Once we have that order, we'll be able to maybe brief you what exactly are the observations.
Okay. 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 But then in that case, Swapnil Srivastava, even if the matter goes to the Supreme Court, and we've just heard from the kin of the two people, the two 24-year-old techies who were crushed to death by this 17-year, 8-month-old child, quote unquote. Even when it goes to the Supreme Court will say we are bound by the law. Everyone is bound by the law, then what happens to justice? Again, I'm saying look, the Bombay High Court did what it did after interpreting the law of this country. That's exactly what the Supreme Court will do. What about justice for those two families in two different parts of India who've lost their child? You want to do your best for a quote-unquote child who has killed two people, but you don't want to do justice to the two people who've actually been killed.
I understand your point, but we shouldn't lose faith in our system just yet. Because so far as the question of justice for the families of the victims and the victims are concerned, the trial will take place and punishment will be prescribed. After this issue was highlighted, more stringent sections of culpable homicide were also added against the juvenile. So let us not confuse the purpose of a bail hearing with that of the final trial that will take place, wherein punishment will be prescribed if the person is found guilty.
You know who the punishment it will be for? The punishment will be for the two families who are watching this broadcast today and whose pictures you're seeing on your screens. Just like the process had become the punishment for Nirbhaya's parents. Right? They are the ones who will face the brunt of it. Why don't I ask that question to Akhilesh ji, who's also with us on the show. He's Anish's chacha. Akhilesh ji, can I just get you into this conversation once again? आपको लगता है कि आपकी फैमिली को जिस तरह से ये केस प्रोग्रेस हो रहा है, जो भी हुआ अब तक, हमने देखा कि पूरा सिस्टम ही कॉम्प्रोमाइज्ड है, बिकाऊ है. आपको लगता है कि आपके परिवार को जस्टिस मिलेगा?
देखिए, जस्टिस तो मिलेगा, बल्कि ये जस्टिस हमको कब मिलेगा इसकी हमको कोई अभी प्रोबेबिलिटी संभावना अभी नजदीक नहीं रही. जिस प्रकार से केस की कार्रवाई चल रही है, अब उन्होंने किस प्रकार से एविडेंस क्रिएट किए हैं, अब जो माननीय न्यायालय जो हाई कोर्ट, वो यदि इस प्रकार के पूरे व्यू को देखने के बाद इसको मानता है कि ट्रामा में है, तो अब जस्टिस मिलने की हमको कहीं संभावना नहीं दिख रही. माननीय न्यायालय से हमको जस्टिस मिलना था, जब उनके इसमें आ रहा है, तर्क में आ रहा है कि भाई ट्रामा में, अब वो क्यों ट्रामा में है, उसका क्या उन्होंने किस प्रकार से उसको निर्णय लिया कि वो ट्रामा में, मैं नहीं कह सकता. इसलिए भी जस्टिस की गुंजाइश कम दिख रही है.
Naveen Chomalji, I'm going to bring you in here. You're the lawyer in the you're a lawyer yourself. I want to ask you where you stand in the entire proceedings as they have gone on in the Bombay High Court. It comes to my mind that, you know, given that many of us have already made up our minds on how this boy should be treated, is it less because of what he's done, and what he's done is heinous, and more because of what his parents did?
Let me try to express my thoughts and views on all the aspects that you have covered, which are really very important. First of all,
Mr. Chomal, but answer my question as well.
Yes. Being a lawyer, it is my duty to explain the entire law to our esteemed audience, which of course my colleague lawyers have already
No, Mr. Chomal, that law has been explained twice. Yeah,
yes.
Mr. Chomal, that law has already been explained by two lawyers on this show.
Yes,
Please
I'll
don't
not
repeat yourself.
I'll not
Our
repeat.
viewers
I'll
understand what the law says.
Yes. So firstly, what the thing is, your concerns are really very important. There is no doubt about it. But you please appreciate that this case is one rare case in which such a heinous crime has occurred, which has shaken our conscience and everything. But the object which the particular act wants to achieve for the society, particularly for the young children who are misguided, who enter into the field of crime, so they should be protected, they should be given a chance to lead a life away from the crime. So the purpose of the law, section 12, as what our Honorable High Court has put a finger on today and given the benefit to the child in conflict with the law, is that he should not be detained and put under detention, and he was given the custody of his aunt. So that is a proper step taken. But of course, with due respect to what you are saying, and even Vikram Singh said, also my friend Swapnil said, and Mr. Patil also said, that there is a scope under section 15 for trying the child as an adult also. So let the particular Juvenile Justice Board decide on the matter, and if they have the proper material, as you rightly said, that he was found to be drunk and is just 4 months lesser than 18 years of age, so his mental health can be considered, and in that case, definitely he can be punished. But you recollect in Nirbhaya's case also, the main culprit, Mohammed Afroz, he was let off very easily in the crime. That crime was far serious crime as compared to this particular crime. So, in certain exceptional cases, there occur some instances where our
two wrongs don't make a right.
is shaken. But ultimately, the entire purpose of the law,
and it is after what happened with Nirbhaya. Correct, but it is after what happened with Nirbhaya that there was a big conversation about 16-year-olds and above involved in heinous crimes be treated as adults. And you speak of the Juvenile Justice Board and the fact that it is the Juvenile Justice Court that will decide whether this 17-year-old, 8-month boy should be tried as a minor or an adult. Just to tell you a bit about the Juvenile Justice Board, the Juvenile Justice Board gave this boy bail within 15 hours of him killing 2 techies in Pune who were returning home from work.
Raji, well taken.
After asking him to write a 300-word... 1 minute, Mr. Chomal. 1 minute. After asking him to write a 300-word essay, you kill 2 people and you're asked to write a 300-word essay to be let free? 15 days of voluntary service with the traffic police and seeking counseling for your drunken habits. This is what the Juvenile Justice Board did. Give this boy bail within 15 hours of him killing 2 people after asking him to write a 300-word essay. We should all question, if we are questioning the Pune police, which we are, we should all question the Juvenile Justice Board as well. Again, and ask that question. Today what has happened under what the law says. But is this justice? Is this justice to the 2 families who lost their children? To protect 1 child, will you not do the right thing for 2 other families in this country?